And the Supreme Court is hearing arguments today in a case that could have major implications for the midterm elections. A Republican congressman is suing to ban the Illinois Elections Board from counting ballots received up to 2 weeks after an election. ABC News senior legal contributor James Sample is here for more. Hi, James. Thanks for coming on. So the key question in this case is whether candidates have the standing to challenge state election laws. How do you expect each side to make their case?
Diane, it's good to be with you. You're right that the key question is standing. And the question really boils down to the underlying fact pattern in the case is about mail-in ballots and whether challenges to mail-in ballots can proceed. But the individuals who are bringing this suit are alleging, in essence, that they as candidates and they as electors in the state of Illinois are harmed sufficiently to comply with the Constitution's Article 3 requirement that they be injured in fact in order to satisfy standing, which is to say that they have the stature to bring the case. And this particular context is if these candidates have standing to bring this case, that will open up a range of challenges to a broad array of election laws, because these individuals, these are statewide laws that apply to everyone equally, and alleging that you have a particularized harm just because you disagree with the policy is typically not sufficient to provide standing to bring a lawsuit. So if there is standing in the case, then you'll get to the questions of whether or not mail-in balloting, which has long been a target of President Trump, even though President Trump performed quite well in mail-in balloting in the last election, and Republicans have historically performed quite well with mail-in ballots. Then we'll get to those questions on the merits. But you're right that this is all about whether these parties have the standing to challenge this in the courts, as opposed to going to the legislature if they don't like the policy.
Yeah, this is sort of the step one before you even get to the step two. So, James, the justices are also considering a challenge to state laws banning so-called conversion therapy. And the question in that case is whether talk therapy is protected speech or regulated medical conduct. I want to play some of the attorneys' arguments for you.
So this court has recognized many times in cases like McCullen that a one-on-one conversation is a form of speech. And that's exactly what's going on with Ms. Childs and her clients.
This has been an area that has been heavily regulated from the beginning of our country, and no one has ever suggested that a doctor has a First Amendment defense to say the wrong advice to their patient.
What did you make of those arguments, and what stood out to you from the justices' questions?
Well, unsurprisingly, the producers chose very good excerpts that boil down, that really encapsulate the argument. It took 90 minutes, but you essentially captured those 90 minutes of oral argument from yesterday in those two clips, which is to say that the dispute in this case is whether talk therapy, which obviously involves a component of speaking, boils down to speech and therefore is beyond the scope of regulation per the First Amendment, or whether talk therapy is a form of treatment like other forms of medical treatment, in which case the state has the power to regulate treatment consistent with the standard of care. And so talk therapy, the scientific and medical consensus, the psychological consensus is that it does not work, that it actually produces significant harm for the individuals who are subjected to it. But there are counselors who want to engage in talk therapy, which is basically trying to persuade people who think that they might be gay or think that they have some questions about their gender identity to be heterosexual, even if they think they are not heterosexual. The science on this says Colorado is right to ban the practice. The First Amendment, however, may say that it is an infringement on speech. And reading the tea leaves of oral argument yesterday, Diane, it seems pretty clear that there is a core majority that is ready to strike down Colorado's ban, and that would carry with it striking down the bans of 27 states which have similar bans in place.
And James, as you mentioned, the justices appear to be leaning toward ruling that those laws, at least to some degree, infringe on the speech of licensed therapists. So is there a way that they may say that the laws are too broad and the language needs to be more narrow? Is there sort of a middle ground here, or is this all or nothing? Either they uphold these laws or they strike them down.
It's a really good question. I think there's a chance that they remand these cases to the lower courts and let the lower courts figure out some of the details or the kind of compromises, if you will. But I think that the most likely scenario here is that the court will will not get into the weeds of drawing those very subtle lines and the line drawing. The court will likely strike down these bans, and then it'll be up to the legislatures to see if the legislatures can come up, if they want to come up with something that is not violative of the First Amendment, but that does accomplish some of the goals that these bans were intended to accomplish.
All right, ABC News legal contributor James Sample, thank you.